Our first bill that we'll be discussing today is House File 600, Legalization of Adult Use Cannabis. Majority Leader Winkler, I know this is your bill, and since you're not a member of this committee, I will move the bill for you. I will move that House File 600 be recommended to be re-referred to the State Government Finance Committee. Representative Winkler, welcome to the committee, and please tell us about your bill.
Thank you, Madam Chair, and thank you, members of this committee. This is a very important hearing today, and the work that you're doing could not be more timely in this moment. House File 600 is part of a package of bills that needs to be discussed today. The purpose of House File 600 is to eliminate the harm that cannabis has in our society. The primary harm that cannabis poses in Minnesota is the prohibition and criminal enforcement of cannabis. The goal of House File 600 is to shift an illegal marketplace that is policed and over-policed disproportionately, and instead to create a policy of repair and opportunity for those most adversely affected by the war on drugs. In Minnesota, whites and African Americans use cannabis at approximately the same rate, but arrest records are hugely disproportionate. According to the ACLU of Minnesota, anywhere from an African American is 4 to 10 times more likely to be arrested for a cannabis possession charge than a white Minnesotan is. This committee does not need any information from me about the consequences of those arrests, the consequences of those stops, the consequences of felony convictions, not only for the person who has the conviction, who may undergo, of course, prison time, but also have a very long period of probation, may have difficulty finding housing, finding jobs, be disqualified from voting, have a difficulty supporting family members, and have a difficulty being an active and supportive member of our society and in their community. Cannabis does have some harm. It is not conducive to the development of adolescent brains, and it can, in certain cases, exacerbate certain psychological conditions. Cannabis, however, is much safer than legal substances like alcohol and tobacco, which we regulate and tax. The approach of House File 600 is to address the real harms of cannabis and create an opportunity for Minnesota to move past a failed policy that disproportionately impacts people of color, and instead create an opportunity for those communities most adversely affected to participate in a legal regulated marketplace with jobs, with business ownership, and with expungement of criminal records. For this committee's jurisdictional purposes, I'd like to just briefly describe the expungement provisions of this bill. We have expungement in Minnesota. It is a cumbersome process. This bill seeks to make it automatic for those who have less than a felony conviction. If you have a felony conviction on your record, if you are incarcerated, the Bureau of Criminal Apprehension is directed to identify those individuals and to submit their records to a court for a legal expungement order. If you have a felony conviction or above, we create an expungement board, a cannabis expungement board, tasked with reviewing those records and determining expungement or some reduced sentence. The goal is to eliminate those records that that are attached to people who have engaged in activity that was criminal but is now seen as an illegitimate criminal prohibition by more than 2/3 of the public. The criminal justice system cannot legitimately use the power of arrest, the power of conviction, the power in some cases of taking life for a use of a substance that more than 2/3 of the public believe can be used safely and should be legal. It is not legitimate. That is the goal of this bill. I'm happy to talk at length about the ways in which we create a marketplace in which individuals and communities adversely affected by cannabis can participate. We provide funding and grants to people to participate in the market. We provide direct community grants for those adversely affected by the war on drugs. But the goal and the whole structure of this bill is to end prohibition, and not just end it, but then create real opportunity for those who've been hurt by prohibition. And Madam Chair, I'm used to a different forum. Madam Chair, I think there are a number of testifiers, and they can speak to the provisions of this bill.
Thank you, Representative Winkler. And it's my understanding that we have about 4 testifiers who are here in support, a couple with concerns. So members, my intention is that we'll get through all of those testifiers and then we'll move to member questions. I believe your first testifier is Munira Mohammed.
Madam Chair.
Oh,
Madam Chair.
it's Representative Scott.
Thank you. Thank you for recognizing me. Real quickly before we get started with testimony, do you know how much time is allotted to the discussion on House File 600 today? Or is it open-ended?
Thank you, Representative Scott. I would like to try to move to a vote by 1:30 today, but we do have some extra time, according to House Media, to go a little bit longer with this hearing.
Madam Chair.
Representative Scott.
Thank you, Madam Chair. I don't think that's going to be enough time. I have a multitude of questions. There are more areas of this bill that relate to the what we oversee in this committee than just the expungement pieces. There's a lot of data practices. There's a lot of boards set up here that are going to be dealing with a lot of issues and data. There's penalties. I just don't think, because that's going to be about 20 minutes. And I don't know how long each testifier is going to be testifying, but I would ask for more latitude for our members to discuss this in more detail than just in 20 minutes. Couldn't be done in 20 minutes. Thank you, Madam Chair.
Thank you, Representative Scott. Let's just get going here with the testimony, and with your comments that you do have a lot of questions. I'll just remind testifiers that we do have a lot of member discussion. So if you can keep your testimony as tight as possible and to those areas that are most impacted by this committee in the bill. I'll note that this bill has made a number of other committee stops and that many members have already seen this bill in other committees too. But I do think it's important with respect to the provisions that are at issue before the Judiciary Committee that we have time to discuss those. So I will go ahead and move to testifiers, and I believe you have turned your camera on. So go ahead and introduce yourself and you can begin.
Hello, everyone. Chair and House Representatives, my name is Munira Mohammed. I'm the Policy Associate for ACLU Minnesota, and I'm here to speak today in support of House File 600 regarding cannabis legalization. And I'm sure none of you are strangers to this topic, so I will be as brief as possible. Cannabis laws desperately need reform due to the stark racial disparities in marijuana possession arrest and the fact that they haven't gotten better in Minnesota or nationwide. Nationally, on average, a Black person is 3.6 times more likely to be arrested for marijuana possession than a white person, even though Black and white people use marijuana at similar rates. Here in Minnesota, a Black person is 5.4 times more likely, 5.4 times again, to be arrested than a white person, which is significantly higher than the national average. The disproportionate targeting and over-policing of Black communities for a substance that is equally used amongst the population is a natural consequence of marijuana criminalization and the byproduct of the failed war on drugs. It goes without saying that the personal cost to those arrested can ruin lives. Being caught with even the smallest amount of marijuana can risk your housing status, employment opportunities, child custody determinations, immigration status, and your eligibility for financial aid. House File 600 is a viable path towards legalizing marijuana use and possession for Minnesota adults. It has strong provisions that don't simply replace marijuana prohibition with a system of onerous fines and fees, which can drive families into debt and economic instability. It also provides clemency or resentencing for certain marijuana convictions that people have been incarcerated for, and the expungement of past marijuana convictions. We sincerely hope that the legislature takes quick and serious action on moving this forward. If full legalization does not occur, we will see further arrests for possession, ever-increasing prison populations, and the criminalization of Black and Brown communities. ACLU Minnesota urges you to support House File 600, and a big thank you to Representative Winkler for bringing this forward. Thank you.
Thank you, Ms. Mohammed. Our next testifier is Larry McDonough. Welcome to the committee. Please introduce yourself and you can begin.
Thank you, Representative Mueller. My name is Larry McDonough, and I'm Senior Minnesota Counsel with the Lawyers Committee for Civil Rights under Law. And I've put together a very quick slideshow of my comments on the bill. Here's my information about myself. The Lawyers Committee supports the bill. Criminalization of cannabis has caused denial of housing and evictions, both of which lead to homelessness. And while the House File 600 will help with denial of housing, to help with eviction, it will need a couple of amendments. So quickly about denial of housing. Criminal records are used quite a bit in applicant screening, and illegal drug activity is a common basis for rental application denial. The links to these studies are active, so when you get this on your website, you can take a look at the studies and details if you wish. Another study looked at around 10,000 households and 15,000 individuals and looked at the links between criminal history and housing outcomes and found that there was no evidence of any link to bad housing outcomes from prior use of marijuana. But the fact that criminal histories are used a lot in tenant screening has led to some regulatory ordinances in Minneapolis and St. Paul. So this bill will help by taking kind of the cannabis use and legitimizing it and taking that out of people's criminal history and making it less likely they'll be denied housing on that front. Tenants can be evicted for illegal drug possession under 504B171, and some cities actually require force landlords to evict tenants for legal use to keep their rental licenses, whether the landlords want to do that or not. House File 600 doesn't change this. Article 1, Section 8 says that tenants can use cannabis, adult tenants, if explicitly permitted by the owner. This means that use where the lease is silent would be unlawful and would support eviction. So a couple ways to deal with this would be to kind of change the language in subdivision or little section 2 here as written. This one option would allow tenants to use cannabis, adult tenants to use cannabis on the property unless forbidden by the landlord, but just editing it this way would still lead the tenant subject to prosecution if the landlord forbade use and the tenant used it. And so the amendment that we would prefer would to carve out some language specific to landlords and tenants that would say that a tenant can use marijuana on the property while the owner may prohibit it, that a violation of that would not lead to criminal sanctions, but would allow the landlord to evict if the landlord had that in his or her lease. Another change that would need to be made would be to have a change in 504B171 that is not in this bill right now, and to simply create a reference to Chapter 342 in there, and I've got some proposed language where that would fit in the statute. Thank you very much for hearing me, and if you have any questions, I will stick around.
Thank you, Mr. McDonough. The next testifier is Marcus Harcus. Please introduce yourself and you can begin your testimony.
Good afternoon. My name is Marcus Harcus. I'm from North Minneapolis. I've been a cannabis consumer for 22 years and a legalization advocate for the past 7. I've literally heard from hundreds of Minnesotans who have been victims of these unjust prohibition laws, but almost all of them are too afraid to tell their stories publicly, and most are too afraid to even tell legislators privately. Today, I'll read a brief statement from a man who traveled from greater Minnesota to share his story with me in Minneapolis. Quote, as an adult, I have used marijuana socially and personally as a means of helping me to relax, meditate, and sleep. The fact that I find marijuana enjoyable and useful for these purposes has never interfered with my ability to perform in my job as an attorney, nor has it inhibited me in my role as a husband or father. My lone experience with the adverse effects of marijuana had nothing to do with marijuana use at all. I had worked hard throughout law school to position myself to be hired as an assistant county attorney. And when I finally had the opportunity, my wife was 5 months pregnant, and I made preparations for the move. A week before we were scheduled to close on the home, I was making the long weekly commute to the community where I worked, when I was stopped for having a burnout license plate and ultimately cited for possessing 2.5 grams of marijuana. I was not under the influence nor using marijuana at the time. It was simply within my vehicle and in my possession. From a legal standpoint, this resulted in a petty misdemeanor citation and a $300 fine. From a personal standpoint, however, this petty misdemeanor citation was a catastrophe. My employer, when advised of the citation, forced me to resign. This required my wife and I to withdraw from the purchase agreement of the home we were buying and of the home we were selling. On top of that, neither of us had jobs, as my wife had resigned from her position in anticipation of the move. This petty misdemeanor citation cost my family thousands upon thousands of dollars in income and pushed us to the financial brink. All of this had nothing to do with the adverse effects of marijuana use and everything to do with the collateral consequences that come about as a result of marijuana being illegal, unquote. So as this story shows us, the most dangerous thing about cannabis is getting caught with it. Prohibition is the problem, not cannabis, and full legalization is the only solution. Please pass House File 600. Thank you.
Thank you, Mr. Harcus. Chris Wright, you're up next. Go ahead and introduce yourself. Welcome to the committee.
Thank you, Madam Chair and committee members. The only reason I urge you to support HF600 is because we get more justice from the legalization by fraud than criminalization by fraud. But fraud is fraud. Article 13, Section 7 of the Minnesota Constitution says, any person may sell or peddle the products of the farm or garden occupied and cultivated by him without obtaining a license. Therefore, indeed, Section 8 of this bill is illegal and unconstitutional. While artificial entities may be licensed, natural persons cannot. To jail farmers, Governor Floyd Olson in the legislature in 1935 defrauded Minnesotans of this right by requiring an illegal pharmacy license. This historic injustice usurped and defrauded us of our freedom to cultivate without a license. They destroyed public safety, solicited and monetized crime, caused murder, false imprisonment, systemic racism, trigger-happy police, and then they had the nerve to call us criminals. And now you want us to reward this criminal act by giving you police power to defraud us again. And we're just supposed to let you get away with it? Well, cannabis makes you cough, but politics makes you gag. Please, those with integrity, restore our rights, reform our laws, and with any luck, reveal to a doubting world what Minnesota still can be. I invite you to read my proposed amendments for this bill and my extended remarks. Thank you.
Thank you, Mr. Wright. The next testifier is Michael Daub. Welcome to the committee. I don't see you yet, but maybe if you start talking, we'll see you. Please introduce yourself and begin.
Good afternoon, Madam Chair and committee members. My name is Michael Daub. I'm a drug and substance use disorder policy advocate. I'm affiliated with SAM Minnesota. In 2021, despite substantial evidence of danger to public health, the effort to legalize cannabis in Minnesota is reaching a new high following the budding cannabis legalization experiments in other states. I believe that in Minnesota, we must end the false dichotomy that there are only two options when it comes to drug policy, legalization or criminalization. To be blunt, the overall goal of drug policy should be to reduce drug use and connect those who are suffering from substance use disorders with recovery resources. Your choices are not between locking up users and fostering a for-profit industry. As we approach the 50-year milestone of President Nixon's war on drugs, it's time to acknowledge that it's been a failure. Instead, it's time to focus on a public policy in Minnesota stating that drug use and substance use disorders are public health issues. I cannot support the broad scope of House File 600 unless a new public policy is established. Legislation should establish it at once. It's time to hasten the end of low-level cannabis possession offenses and expunge those convictions. We've been painfully reminded again this week that over-policing and incarceration of people of color must end. The recent report from the Minnesota House Select Committee on Racial Injustice includes such recommendations. You should adopt these recommendations at once. In conclusion, turning to cannabis use disorder, it's imperative that help become readily available to those afflicted. In the bigger picture, the availability of treatment for substance use disorders should also expand. Cannabis tax revenues should be placed in a special fund and dedicated to treatment, as promised by Representative Winkler. Education campaigns focusing on research and scientific findings illustrating the danger to public health from cannabis should be immediately expanded, regardless of whether or not legalization proceeds. I cannot support the broad scope of House File 600 unless educational programs about the danger to public health begin. Thank you.
Thank you, Mr. Daub. And I believe our final testifier is Sheriff Kevin Togerson. Welcome to the committee. Sheriff, please introduce yourself and you can begin.
Thank you, Madam Chair and the committee for hearing me today on this very important issue. I am Olmsted County Sheriff Kevin Togerson, representing the Minnesota Sheriff's Association. The Sheriff's Association opposes House File 600 to legalize marijuana. To pass this legislation will not make our community safer and will increase the ability for our youth to access this drug. Currently, our state is in a desperate battle to save lives in an opioid epidemic coupled with serious drug issues at the core of most crime in general across our state, from catalytic converter thefts to murders. Drug use, trafficking, addiction, and deaths are increasing. Now is not the time to take this step. In my review of this bill, and since our association last testified before you on this topic, nothing in this bill has been done to solve the issues most concerning to law enforcement and has created a new concern. The first being youth access. We can all agree our greatest resource in our state is our next generations. To pass this bill will severely impact our youth by making access to this drug more readily available at a time when potency is at its highest in history. Science has also allowed for potency to develop over the years and has created more pathways to deliver this drug to our kids, marketed as candy and as vaping as a safer way to deliver the drug. To think our kids are not going to be impacted by those marketing implications is a terrible mistake. The second issue law enforcement has raised before and not yet accomplished is the safety on our roads, where law enforcement does not have a tool to provide a roadside test. We have had scientific testing for decades related to alcohol in an individual system at the time of contact. There is yet no way for law enforcement to test and confidently know when a driver is under the influence of marijuana at the time of contact other than by observation. Testing currently can only determine if the drug is in the system of an individual, but cannot determine the level in one system. We should all agree to ensure better testing before we move forward with enforcement. Lastly, the expungement clause could severely impact our ability to prohibit persons from carrying and purchasing guns when doing background checks. We all should agree we want to keep guns out of the wrong hands. So on behalf of the 87 elected sheriffs in Minnesota, please do not pass this bill forward today and do not legalize marijuana in the state of Minnesota. Thank you.
Thank you, Sheriff. And thank you to all the testifiers. I don't have anybody else on our list, and I just want to say you all kept your comments succinct, and to remind members that there are a number of written comments also in your packets. I believe Chair Becker-Finn is back, and so I am going to turn the gavel back over to her for member questions.
Thank you, Vice Chair Moeller, for ably handling the beginning of committee. We will get to member questions. Representative Scott.
Thank you, Madam Chair. Just real quickly, and this may swerve over into public safety, but when was it just 2 years ago that we did some reform on um, lowering the penalty on the possession of marijuana? I don't know if the bill's author knows the answer to that question or somebody else on the committee, but was that just 2 years ago?
Representative Winkler.
Madam Chair, Representative Scott, I'm not quite sure what you're referring to, I guess. We made up to 1.5 ounces possession a petty misdemeanor, I think in 1973, but I'm not sure about what we did 2 years ago on that topic, if anything.
Representative Scott.
Okay, Madam Chair. I thought in the last several years, I thought that had done something either on the possession and anyway, I just had some questions to follow up, but if we don't know the answer to that, then I won't ask the question. I'm going to start out my questioning Representative Winkler regarding the statewide monitoring system. And, you know, businesses submit this monitoring data to this through this monitoring system. And I'm just wondering, does the system keep track of patient or customers of the cannabis? Will that monitoring system keep track of that information?
Representative Winkler.
Madam Chair, Representative Scott, I have a feeling that your specific questions on these issues are going to be best addressed to Mr. Johnson from House Research. I am not an expert on those portions of the bill.
Okay.
All right, Mr. Johnson, if you could help us out.
Madam Chair, Ben Johnson with House Research. Madam Chair, Representative Scott and members, the provisions in the bill do not require the collection of information about people who are purchasing marijuana. It just simply requires that the sale be recorded as sort of an endpoint in the distribution from seed to sale.
Follow-up, Representative Scott.
Thank you, Madam Chair. I'm trying to toggle back and forth between the bill and my notes here. I'm just wondering because I'm just wondering if there's going to be, in my opinion, there should be some audit trails created and some role-based access to that information. And I want to get onto a different section. It's a long bill, just bear with me. If we go to page 34, that's where the powers and the duties of the board begin. And there's some data privacy provisions there, Representative Winkler. And it states that there's all of that data is going to be classified as private. It's going to be data submitted for the cannabis license, except for the name and designated address. And one of the next bullet points is the identity of a complainant who has made a report concerning a license holder. And it says explicitly there that even when the investigation is inactive. And I'm just wondering why that information is so special. Normally, inactive investigative data is public data. But in this case, you're keeping it private. And I was just wondering why.
Representative Winkler.
Madam Chair, Representative Scott, I am open to talking that through if you think a change would be useful there. That really, I think we're talking about business entities, and the investigations aren't criminal in nature. They are to determine whether licensing standards are being met. So I think the concept of keeping it private could have the benefit of not adversely affecting the business reputation of licensees who may have no wrongdoing whatsoever. And so, you know, if there's a better way to do it, if there's a better way to make sure that we're not creating an incentive for people to trash certain businesses and get some kind of public record of that, I'm open to figuring that out with you.
Okay.
Representative Scott.
Thank you, Madam Chair. And then the other The other investigative data here that is generally public following the investigation has to do with violations of statutes and rules. And again, maybe in the first instance, since it was just an allegation that was perhaps, no disciplinary action happened. But in this case, there was clearly a violation. And so I'm wondering if that's something that you might also be open to changing. And I feel like if they're found in violation, then that information should be made public.
Representative Winkler.
Madam Chair, Representative Scott, the goal in putting these sections together was to treat cannabis as a business similar to alcohol or tobacco and to essentially apply the same standards. I think, again, Mr. Johnson might be able to provide some context for how we deal with the same questions in those industries. But the policy goal is to essentially treat it like other types of legal regulated business entities, and to have the Cannabis Management Board to have that same level of oversight, but also to treat the records the same. And Mr. Johnson may be able to provide a little context for that.
Mr. Johnson.
Madam Chair, again, Ben Johnson from House Research. Madam Chair, members, the goal of this data was to mirror what's been done with similar data in other states, and also be consistent with the way we talk about and classify, obviously, the individual decisions about what data is public or not public.
Mr. Johnson, we're having trouble with your connection. If you could try turning off your video and try again.
My apologies. Looks like you can hear me now. Again, it's Ben Johnson with House Research. The goal of these sections was to mirror much of what is done in other states for similarly collected data, while also being consistent with the way data collected in similar situations under Minnesota law is done. Obviously, the individual decisions related to the specific data and how it should be treated is a policy decision that's up to the members. Thank you, Madam.
Thank you, Mr. Johnson. Representative Scott, any follow-up? Otherwise, I want to make sure we have time for Representative Johnson and Representative Robbins.
Yes, Madam Chair, I do have some other questions. I want to move on to the medical cannabis and that whole board and the requirements surrounding that. Representative Winkler, did you take kind of the existing medical cannabis law and put it into this bill and just kind of expand it? Or I didn't have time to compare what's in current law compared to what's in this bill. So if you could just help me out there, that'd be helpful.
Mr. Representative Winkler.
Madam Chair, Representative Scott, what this language is attempting to model is essentially the reforms that are moving separately in a bill carried by Representative Edelson of the medical program. So we want to, the overall way that we're doing this is we're shifting responsibility for the medical program to the Cannabis Management Board. We are making sure that medical cannabis is not taxed. We are expanding the ability to use flower through the medical program. And we are really just trying to make the medical program work. What we heard overwhelmingly from Minnesotans is that it's too restrictive, it's too expensive, it's too hard to get access. And that while we're creating a legal regulated marketplace for cannabis, we still need a medical program because there are a lot of people who want to do it in conjunction with a prescription or a referral from their doctor and feel more comfortable under that kind of situation. And we want to have it be non-tax. So the provisions in the bill related to medical cannabis are shifting the existing program, expanding it, and changing some of the guidelines. But Representative Edelson's bill on medical cannabis is really the leading kind of edge on what we're doing, and we're following in her wake.
Thank you, Madam Chair.
Last question, Representative Scott.
And thank you, Madam Chair. And so I had some concerns with that area. I see that you require Tennyson warning, and that's very appropriate. And I thank you for putting that in the bill, or maybe that was Representative Edelson's doing if it's kind of her language. But one of the things that I don't see in here is an opt-out for people. I noticed that a lot of this data is going to be used for research, and there's no opt-out provision here for anyone that's in that program. And certainly I think there should be an opt-out provision. If you don't want your data to be used, your medical record to be used, whether it's aggregated or not, you should have the option of opting out of research. And I had some questions about the liability there too. And my understanding is if a doctor prescribes something that is either not appropriate for you, or it turns out that you have a reaction to what that doctor prescribed and they should have known that it wasn't the right dosage or the right drug for you, you should be held liable. And I'm not seeing in this bill, and correct me if I'm wrong, I could be, it just seems like nobody's held liable here for any of the dispensing of the medical marijuana.
Madam Chair,
Representative Winkler.
Madam Chair, Representative Scott. So that's existing tort law. So if a physician acts or directs a patient to take action that is contrary to the standard of care and it results in harm to that individual, they have a malpractice claim against the physician. So all the existing common law, tort, and other statutory provisions related to tort law in Minnesota would apply in the medical cannabis program as well.
Thank you, Representative Winkler.
Yeah,
I have more
Representative Scott.
questions. I have more questions, but I'll let my other members ask as well. Thank you.
All right, Representative Robbins.
Thank you, Madam Chair. Sorry, I'm having trouble with my video, so I keep trying to make it work. I have so many questions as well. I would say the first question I wanted to ask, and I was just looking on the bill for the actual line number, but it's in section 5, I believe. And basically it has to do with the relationship with the courts. And sorry, I'm looking for my page here. So basically, it seems like this board can oversee or tell the courts what they can do. And I just wondered, Representative Winkler, if you could address that. It says that the board determines if someone is eligible for resentencing or a lesser sentence, and the court must proceed as if it's been directed by an appellate court. So I'm just worried about the separation of powers here. How can this board have that authority, and does the court have to abide by it?
Representative Winkler.
Madam Chair, Representative Robbins, yes, the point is to make it automatic so that you don't require a person to apply or to make some kind of showing, hire a lawyer, take active steps themselves, but rather to determine whether the criteria in the statute have been met, and then have the order issued directly by the court. So an expungement is a court order, and this is an automatic order that will be issued based on the findings of this board. In the case of lower level cannabis convictions, the board doesn't even have to review it. It's simply a matter of the BCA providing a list of individuals to the court for those orders to be issued.
Representative Robbins.
Thank you, Madam Chair. Thank you, Representative Winkler. So have you spoken to the courts about this, and are they supportive of this?
Representative Winkler.
Madam Chair, Representative Robbins, I don't recall actually meeting specifically with the judicial branch about this, but I don't have any separation of powers concerns regarding this bill. The judiciary is still subject to state statute, just like every other branch of government.
Representative Robbins, and then we're going to move on to Representative Johnson.
Thank you, Madam Chair. I do have, well, I have a lot more questions, but I'll leave it to one more. In section, I can't remember the subsection, but it's line number 22.19 and following the bill, it talks about violations and penalties. And basically, it gives the board the ability to assess civil penalties for all the different levels that could be perceived as a violation. And I just found this very unusual that a appointed board would be able to assess civil penalties on individuals. And when I read the language, it doesn't seem to say, you know, does the majority of the board decide? Does it have to be a unanimous decision? So could you talk more about why you're giving this ability to assess penalties, civil penalties to the board? Is that done anywhere else in statute? And then what sort of level of unanimity is required or majority to make the penalties be assessed? Thank you.
Representative Winkler.
Madam Chair, Representative Robbins, it's a regulatory board, so it has all the administrative law authority to issue rules, make findings, and issue penalties, which of course are appealable then to a court. It certainly does not have criminal jurisdiction over individuals.
Right. I see that. Do any other regulatory boards? Oh, sorry.
Representative Robbins, and then we really do need to move on to Representative Johnson and the vote.
I'm sorry, I'll defer to Representative Johnson. Thank you, Madam Chair.
Yep, Representative Johnson.
Chair Beckerfield, members, give me a second here. I have the distinction of being in two committees at once here, so I'm trying to keep them straight. I'm looking at this bill and I do have problems with it. I'm sure everybody knows that. But I'm wondering, there's civil penalties if somebody is over their number of plants in excess. Looks like the person can grow 8 plants with 4 mature plants at one time. But then I look at the grid for penalties. If a person has 4 plants, that's equal to approximately, if they're well nourished and well maintained, that's about 4 pounds of marijuana. And I look down through the grid. If he's transporting it from where he's growing it, then it gets caught. There's civil penalties for the of $25,000. The person is within the guidelines with his 4 plants. He has, but he's over the amount that he can legally carry by 4 pounds. I'm just wondering how, even though it's a civil penalty, and is it my understanding that Representative Winkler, that the board is going to be assessing these penalties?
Representative Winkler.
So, Madam Chair, Representative Johnson, I just want to clarify one thing. The permission to have, or the authority to have home grow and to have, I think, up to 10 pounds at home is different from the right to transport it. The idea is that if you have it at home and you use it at home for your own personal use, that is one set of activities. It is very different if you start carrying large amounts around other places, because then it begins to look like you are engaged in distribution in an illegal market. If you wish to purchase, and bring it home, you are subject to restrictions on how much you can carry, where you can consume it, where you can possess it in certain cases. You can't sell it to minors. There are all sorts of restrictions built around the continued use, transport, and sale of cannabis if you are not within the regulated marketplace. And the exception is the home grow, but that is intended to be raised and cultivated and used in your home, not transported.
Follow-up, Representative Johnson.
I'll leave it at that. I do have just one more thing. A friend of mine that I met at my church wanted to testify today. Unfortunately, he does not have a phone or access to a computer right now to call in to testify. Had a great conversation with him. The gentleman's name is Ted. He's still planning that one of these stops to testify, but I wanted to relay some of the information that he passed on to me. In talking with him, he is against this bill. He's in drug rehab right now. He's doing very well in the program. And when he heard about this proposal, he was very upset. He started with marijuana and got that first high. And it made him work to get more and more in different highs. It devastated his life. It wasn't because of charges dealing with marijuana. It's because marijuana got him into other things. He lost his child. It was taken away because of his drug use and the other crimes he committed because of the drug addiction. So he has a lot of concerns with this because he understands what marijuana actually does. We're hoping to get in one of these next stops, get Ted to be able to actually testify, so he can tell his own story. With that, I'm going to request members of my committee not to vote for this. I appreciate what the sheriff said as well. It's going to be detrimental to the safety on the roads. The Colorado study has already proven that. With marijuana-related death, fatal accidents up dramatically in Colorado. But with that, I will leave it there. We can move on. Like I say, right now, this is not a good idea to pursue this. You have states that have had a number of issues. And with that, I will turn it back over to the chair.
Thank you, Representative Johnson. And was going to move us to the vote, but I do see Representative Novotny that you have your hand up. Out of respect to you, I will go to you for a question, but we'll just remind members that we have 4 additional bills that we will be hearing today, and I will not be rushing through that. I think those are incredibly important bills, and so if we could just keep that in mind as we figure out what to ask on the record and what might be able to be asked later on in conversation with Representative Winkler or others. Representative Novotny.
Thank you, Chair. I'll be brief. The question is for the author. You've got specific immunity built in for the board and the governor and employees of the state agencies. What situations would you see where the governor would be civilly liable, and why is that important in the current environment?
Representative Winkler.
Madam Chair, Representative Novotny, it sounds like we're getting close to a qualified immunity kind of question. And qualified immunity for public officials is intended to protect them from individual liability when they make errors in their job or make mistakes. And there's a lot we could have conversations about with respect to what the doctrine is, how it's evolved over time, how it's used or misused, and who it applies to. And I think that is a subject for another bill today. In general, qualified immunity protects from civil liability the errors in judgment of public officials. It's a longstanding protection, and it probably needs some significant reform, but that is not the purpose of this bill.
All right.
Follow up.
Yep. Quick follow up, Representative.
I'd just like to point out this is part of this bill, page 81. So it's not about the next bills. So thank you.
All right. Thank you. Closing comments, Representative Winkler.
Thank you, Madam Chair. So first of all, I just want to clear up some misinformation. In fact, the bill does have prohibitions on marketing to children. It is impermissible to sell or market products that are appealing to children. So there was no candy, there's no colorful characters or anything of that nature permitted under the bill. It's a lesson learned from Colorado, which made early mistakes in that. We are in fact providing more training for drug recognition experts in law enforcement in this bill. We are providing additional funding and continue to do more for substance use disorder counseling and treatment. We are actually doing the things that the critics of the bill would like us to do in this bill already, and we are very open to doing more. This is a responsible approach to cannabis. This is an approach to cannabis that will actually prevent more people from getting misinformation, from getting access to cannabis as youth, and will actually allow us to have a rational policy that protects public health. Prohibition has not succeeded in doing that. It is time to end prohibition of cannabis, create a safe, legal, regulated marketplace, correct past wrongs of the war on drugs, and move forward as a state. Cannabis legalization is coming, and it is time for Minnesota to get it right. That's what this bill represents, and I ask for your support today.
All right, thank you, Representative Winkler. Vice Chair Moeller renews her motion that House File 600 be recommended to be re-referred to State Government Finance. The clerk will take the roll.
Chair Becker-Finn,
Aye.
Representative Moeller,
Aye.
Representative Scott,
Nope.
Representative Feist,
Aye.
Representative Frazier,
Aye.
Representative Grossell,
No.
Representative Hurt,
Aye.
Representative Hollins,
Aye.
Representative Johnson,
No.
Representative Liebling,
Aye.
Representative Long,
Aye.
Representative Mortensen,
No.
Representative Novotny,
No.
Representative Farr,
No.
Representative Robbins,
No.
Representative Fang, Representative Fang, Representative Zhang.
Aye.
There are 9 ayes and 7 nays.
All right, with 9 ayes and 7 nays, the motion prevails and House File 600 is recommended to be re-referred to the State Government Finance Committee. Thank you, Representative Winkler, and to the testifiers.